In section 5 of the legal context lecture, we're going to talk about a variety of legal issues or laws that we need to be aware of in the hiring process, in the staffing process. Some of it is directly related to Title VII application of those laws, and some of them are not necessarily related to that. But nonetheless, these are all issues that we have to be aware of as we are in the staffing process. So the first thing that we're going to address is the failure to hire lawsuit. And a failure to hire lawsuit comes from the fact that an employee, or not an employee, an applicant is arguing you didn't hire them for illegal or inappropriate reasons. So they are charging you with disparate treatment. Now, if we have a track record of an employee and we know that they are a poor performer, that's an easy justification for making an employment decision, whatever that might be. If we've got a long record of someone who is a poor performer, who didn't do well on the job, showed up late, went home early, all those sorts of things, it's very easy for us to defend a failure to promote or failure to, transfer somebody to a different job. But in a failure to hire, we don't have that track record to fall back on. We can't look at that employee's record and know whether or not they would have been a good employee. We are simply judging it based on the selection criteria that we used. So how do we manage this? One of the most important things that we need to do is make sure we've got a really good job description and that we are documenting every decision that we are making based on sound selection criteria. So we make sure that we're not using tools that have an adverse impact. We want to make sure that we're using job-related criteria for making our decisions and we know have been validated to predict good job performance, that we are working really hard to have good documentation of every decision that we made and have that documentation support the decisions that we've made, step by step in that process. So again, making sure that the recruiter notes and interviewer notes are all really clear, not arguing that we used illegal criteria for any particular reason at all. Overall, the biggest issue to avoid failure to hire lawsuits is to treat people kindly and fairly during the selection process. When we treat people like a commodity, when we don't treat them with respect, they will feel disrespected, and at that point they might feel that maybe there was some illegal criteria that went on in the hiring process, and so they're more likely to sue you if they feel like there was something that just wasn't quite right during that process. So, applicant reactions are an important part of our staffing system, and we need to be respectful of treating people kindly, fairly, respectfully, and then that decreases the likelihood they'll feel aggrieved and need to sue you if they don't get the job. Other legal issues that we need to be aware of is negligent hiring. And with negligent hiring, basically that means we should not hire somebody that we knowingly recognize would create harm to our customers, our employees, or to any third party, for example, a repair person in our organization. We are liable for all of those people's safety in our organization. So in order for that to occur, in order for negligent hiring to happen, there's 5 criteria that need to occur. Number 1, that there was an existence of an employment relationship between the employer and the worker. So the worker that was quote unquote negligently hired has to have a formal working relationship, an employment relationship with us. That employee has to have documented unfitness for whatever reason. And this could be violence in the workplace, it could be harassment behaviors, whatever it is. Number 3, the employer's actual or constructive knowledge of the employee's unfitness. And what that means is means that when we did a background check or we did a reference check, we knew or it was safe to assume that the individual was unfit for the job for whatever reason. And if we knew or we didn't do due diligence to find out, for example, if we failed to do a background check and found out that somebody had child abuse in their history and they're now working with children, that would be inappropriate. So we have to, what number 3 is getting at is if we found out the information and didn't act on it, or we didn't do our due diligence to get the information by neglecting to do a reference check or a background check, those are the two criteria in which that would occur. Number 4, the employee's act or omission causing the third party's injuries. So the employee has to be the one that perpetrated the injury to the individual, whatever that is, whether it's harassment, whether it is, violence, whatever in the workplace. And then the employer's negligence in hiring the employee as the most likely cause of the plaintiff's injuries, which basically means that we hired this person knowingly and kept them on knowingly that they were engaging in negative behaviors. So basically, if we knew that they were violent, or we knew that they were going to commit a crime, or we knew we had evidence that there was crimes committed in their past or abuse committed in their past, and we hired them anyway, we can then make the link is then made between us knowing that information, the employee doing the behavior that we were supposed to be guarding against, and somebody got hurt, and that it is the negligence is what caused the problem. So similar to this is negligent retention, which means when I see something and I know it, like if I know that one of my employees is engaged in harassing people or abusing people, and I continue to hire them, and I know that my employees and my customers and my vendors are at risk because this person is behaving illegally and inappropriately, that's negligent retention, and that's also a legal issue that I have to be careful about. So if you know somebody is inappropriate on the job, you are obligated to do something about it. And then with negligent hiring, if you know that somebody was inappropriate, you are obligated to not hire that person if you know that they're going to pose a risk to your company, and you are obligated to engage in the behaviors necessary to pre-screen those things out by doing background checks and other kinds of pre-screenings and reference checks. A negligent referral is one of the more controversial issues because HR professionals tend to get caught between a rock and a hard place. And what we mean by that is they are obligated to give an appropriate reference. If, for example, you have to disclose if you know that someone is violent or is a harasser or has done behaviors that can put people at risk in your organization. So if you don't share that truthful information, you can be sued for negligent referral. Alternatively, if you provide information that is an unprivileged publication of a false statement about someone, which basically means, if you get through the legal speak, it basically means if I sort of heard a rumor or that this person did something wrong and then I shared that rumor with somebody, I have unprivileged information. I'm not privileged to have that info. And then I'm sharing this with somebody else. It becomes sort of secondhand info. And it harms the reputation of the individual. This creates a problem too. So if I have absolute privileged firsthand information that someone embezzled money or did something violent in my organization or was charged with harassment and lost their case, that person lost their case, they were guilty of harassment, and I don't share it, then I am guilty of negligent referral. But I have to be careful how I handle that so I'm not subsequently charged with defamation of character for the individual because I am sharing a false story or sharing a story that I don't have firsthand evidence was truthful. So a lot of companies get away with this by simply giving the bare minimum. Yes, they work for me from this time to this time, and that's it. In my mind, if I'm asking for a referral on someone for the job, I am happy to accept that they're only going to tell me the beginning date and the end date of their employment. But I try to ask the question, are they eligible for rehire at your company? And if you ask them if they're eligible for rehire, the company can say yes or no. Sure, they can come back. Well, then okay, then probably there aren't any major issues there. But if they say, well, no, they're not eligible for rehire, they will no longer be allowed to work here, I don't have to know what's going on. All I have to do is know that that person is not allowed to go back there, and there may have been something substantive that I should be aware of. And then that's information that helps me to make a decision whether or not I want to bring on that person in the organization. Maybe I need to dig a little deeper to figure it out. Alternatively, again, if someone's asking me for a reference, I'll do the same thing. I'll say they began here such and such a date, they ended here in a such and such a date, they are eligible for rehire, or they're not eligible for rehire, and leaving it as simple as that. You don't have to get into details. You don't have to do more information than that. You can simply state a truthful situation and a truthful fact that yes, they can work for me again. No, they are not allowed to work for me again. Trade secret litigation is something that organizations need to do to protect themselves. If they have employees that are leaving their organization, they want to make sure that they have documentation in place, like confidentiality agreements or incompetence agreements or non-disclosure agreements that protect the company from allowing an employee to take trade secrets away. Companies have to establish their own competitive advantage. Remember, we talked about this in the first lecture, right? That the competitive advantage has to be inimitable, difficult to replace, difficult to substitute in order to make this competitive advantage work. And trade secrets are one ways that organizations do that. So how do we manage this? First of all, people are not allowed to take information that they gain from the company and use it elsewhere. And that could be formulas like the Coca-Cola formula or the Kentucky Fried Chicken secret recipe. Any confidential business or proprietary information for the business, any strategies that the company's partaking in, a marketing strategy or a business strategy or a mergers and acquisitions strategy. They're not even allowed to bring customer lists from one location to the other. Those are owned by the company. The employee does not own them, and they do not have the right to get them and take them to another company. All companies have some level of secret, whether it's a strategy or a process or a formula or a product, you name it. Every company has this, and every company needs to protect themselves against this. So trade secret litigation doesn't happen just when you're working for the company. It can happen after the employee leaves and they're working for someone else, and you find out that information was leaked and that suddenly their new employer has this information, whether it's your customer list or the secret formula to your special product or service. So each company needs to protect their trade secrets through legal non-disclosure agreements and incompetence and confidentiality agreements. Interviewers should not be asking employees or potential new employees that information, like trade secrets and things like that. And if they hear an employee say, I have these trade secrets, I have these customer lists that I will bring with me, that should be a red flag for you, because if they're going to steal that information from a previous employer, they are also likely to steal that from you. So that's the last thing you want, is to hire somebody who's going to do that. Even if it might feel like, oh, my company will benefit from this, in the end, it could be a huge disaster, and then you've got a negligent hiring issue on your hand because you knew this person was stealing information from another company and increase the likelihood that they would probably steal from you later. So it's really important as you sit down and interview with these candidates that you let them know that that they should not be sharing any proprietary information from a previous employer, so that they don't put themselves at risk and the company is not at risk for accessing information they shouldn't have access to. The remaining slides are getting at best practices for making sure that we have good equal employment, that we have minimal litigation, minimal legal issues for our company. And the first thing is sort of from the EEOC, there are a number of best practices that organizations should engage in to make sure that they are doing a good job with staffing and minimizing their liability. Number one, comply with the law. Your job is not to figure out how to shortcut the law, but your job is to figure out how to comply with the law and advise the company accordingly. If you have any doubts about that, you always go to an employment law attorney to advise you. You want to make sure that you are promoting equal employment opportunity for everybody, not just for women and minorities, but all groups need to benefit from equal employment. So everybody has an equal chance of getting a job. Everybody has an equal chance of getting promoted. Everybody has an equal chance to get the training they need to advance in the company. Everybody has to have that opportunity. A good EEO best practices also address barriers that affect equal employment. So you want to be thinking about what things are causing problems for us. And it could be that we've got implicit biases, or it could be that we have people who need some sensitivity training or sexual harassment training or diversity training, whatever that might be. We have to figure out what those barriers are, and we need to make sure that we develop a plan accordingly. We also need to make sure that we've got top management team commitment and accountability. So within the management team, there needs to be accountability for bad behavior. So if someone engages in discriminatory behavior, that there's a swift punishment to address that. It doesn't mean that they have to be fired, but there should be a penalty of some sort to address this. Because if the company doesn't handle it in-house, then a lawsuit will come about and create the issue in the bigger picture. We also want to make sure we've got good communication, transparent communication between management and employees. And that includes treating people fairly and kindly and respectfully. We want to make sure that our best practices, our staffing practices, produce good results. We want a selection system that gets us really good employees at the minimal cost that it takes us to get that good employee, so that we get a good return on our investment. We get somebody who's going to work well and someone that's going to help us make good money. So we want noteworthy results on this. Lastly, we don't want practices that engage in or cause unfairness, or perceptions of unfairness, or perceptions that people weren't treated kindly or respectfully. So our best practices always have to be about making sure what we do in our selection system is about treating people fairly and respectfully, and that gets us to where we need to be. So those are the guidelines that the EEOC talks about. The author of this textbook came up with sort of a cutesy acronym for the elements that support a successful EEO program. It's called Splendid, and while it is a little cutesy and maybe a little trite, the words are correct. The guidelines are appropriate and they are smart. So if Splendid helps you remember it, awesome. That's the way to go. So let me go through what those items are. Number one, to study. Know your laws, know your standards, investigate and figure out where your barriers are, and actually do some research and use your resources that are available to you. The EEOC, consultants, professional associations, whatever it takes. Use your resources well. Do some studying, do some research, figure it all out. Planning is also really important. So you want to make sure you have a good plan with respect to how you're going to hire people, how you're going to use your staffing systems, how you're going to plan for good diversity and workforce development. And also, once you do your research and you realize that there are problems, that you are good about setting up a plan to remedy those problems. We also want to lead. We want to make sure we've got leaders who are willing to step forward and set the tone for how things should be done. If you have a leader that continues to behave in discriminatory ways, or in ways that are unfair, that sets the tone for everybody else. So where the leader goes, everybody follows. And I used an example in a previous vignette. One of the slides shows that we were talking about my boss that said, I would never hire somebody who was Indian or Pakistani. That's not good leadership, because now if he's willing to discriminate against people who are Indian and Pakistani because of ethnic origin, what other areas would he be willing to violate the law in order to meet his own issues or biases? So good leadership is necessary, because you don't want your HR professionals to doubt, the integrity of the organization and the leaders behind that. Encourage means, of course, we want to encourage people to engage in inclusive and respectful and tolerant behavior. So we want to link pay and performance around those issues. We want to make sure that we give notice to people on EEO practices and what's going to happen if inappropriate behavior occurs. So part of our training is letting people know, if you do X, Y is going to happen to you. If you engage in this behavior, this will be the punishment. We want to have a discussion, and we want to reinforce the message that diversity is an important business asset, and that the organization needs to support that. We want to make sure that we are including everybody in the process, that not only are our policies inclusive, but that the process was inclusive as well. We gathered information and input from everybody to support that. And then dedicate, assigning the needed resources and staying persistent. So it's not enough to do it once and assume it's going to fix the problem. We have to actively reinforce the behaviors, like any kind of motivation theory, right? Reinforcement theories are important. How do we keep people on track, doing the things that we need them to do? They need regular reminders. They need to know what the consequences are if they don't engage in the proper behaviors. But regardless of what we do, that dedication to the effort is really important, and we have to have that well documented. There are several general barriers to a legally defensible staffing system. So the first one is general decision-making biases. We're all prone to decision-making biases, and the one that's the worst for us in staffing is the similar to me or the like me bias. When I say, oh, I like this person because they grew up in my hometown, or I like this person because they went to my college, or we're in the same fraternity or sorority, that similar to me bias is going to create a problem for you, because then all you're doing is hiring people who are like you, creating homogeneity in the organization. And we all know that homogeneity is what stagnates organizations and creates the problems that they encounter in the end. Other barriers, stereotypes, and we make stereotypes about how women should behave or how men should behave, or how ethnic groups should behave or religious groups should behave. When we engage in stereotypes, we are making assumptions about an individual person based on what we think are group characteristics. And these are, while they're natural ways for our brain to make sense of what we're seeing, they're illegal and inappropriate, and they're harmful. Even what we consider to be positive stereotypes are still considered to be harmful to people. People's ignorance about the law and ignorance about discrimination issues and diversity-related issues, these are also a problem. And we cannot say that we didn't know there was a law in place that said we couldn't, that we couldn't discriminate based on age or sex or what have you. Ignorance of the law is no excuse in the courts. You're supposed to know, and you're supposed to make the effort to know. Prejudices, individual prejudices. Now here's the thing, we all have our prejudices. We all have implicit biases or implicit associations that we make. Some are more, egregious than others, but the bottom line is we all have some degree of adverse reaction to certain groups of people. That's a natural thing, because people who are not like us, we can recognize this. I think we'd all like to believe that none of us have any prejudices in us, but I think that would be a disingenuous thing. And in as much as I try to be as a woke and accepting of differences and tolerant of differences, I know that there are probably fundamental prejudices that I've not looked at, not addressed, and I may be unconsciously acting on. So I can be honest about that. These are the way things are. And as much as I am pro-diversity, I get that. So it really is important for us as an organization to recognize that even if we have personal prejudices, the rules and the policies of the company should be to avoid these prejudices. And so we remind people that your implicit biases, your associations, are not relevant in the workplace. What's relevant is how we work to get along with people. And you don't have to like somebody. You don't have to agree with their lifestyle. You don't have to like the fact that someone's gay or the fact that someone's a Muslim. What you have to do is respect that there are differences. And so prejudices create huge barriers to legally defensible staffing practices. We also have to recognize that what one person considers to be a loss or an issue is not the same for another person. For example, as a woman, I have a very different standard of the way I look at things than a man does. As a lesbian, I also would see the world very differently than I would somebody who was straight. And so my perceptions of what is harmful is different than somebody else. So we have to kind of respect those differences and the perceptions of what one person considers a loss versus another. Lastly, the issue around hiring managers. Hiring managers bring their own biases into play. Even if they're implicit associations and unconscious biases, hiring managers can create the biggest problems for us. And so if you're an HR professional, your job is to make sure your hiring managers are trained on the law and the appropriate questions and why those are appropriate. If you are the hiring manager yourself and you're taking this class, you need to make sure that you remember when you're hiring people to not engage in those, inappropriate questions and illegal criteria for hiring, and avoid those problems. So while the last few slides talked about these broader barriers, these general barriers, guidelines that the EEOC puts out, or these general barriers that organizations need to look at the organization level, there are specific barriers that we need to recognize for recruiting, for selection, et cetera, et cetera. And so we'll talk a little bit about those. Some of the key barriers to recruiting is failing to advertise to diverse populations. Particularly if you're in affirmative action, that is one of your primary responsibilities, is making sure that you are attracting qualified women and minorities from across different resources. And so the more diverse our applicant pool is, the more diverse our organization will be. If you fail to attract diverse applicants, you are creating a problem downstream for your company. You also are going to have an issue if you have recruitment practices that overlook or fail to seek all qualified individuals. So whatever it takes, we want to make sure all qualified individuals are included. You can't say, well, we need more women, so you're ignoring all the qualified men that are out there, and vice versa. We need more men, so therefore we're going to ignore all the qualified women. We need to make sure that we're looking for the best candidates for the job. We have set criteria that we're looking for. We set that minimum criteria appropriately, and then we recruit those people regardless of what group they belong to. And again, the goal is to have a diverse pool so we increase the likelihood of finding the best candidate for the job. Another issue that we end up having is relying on word of mouth or informal networks. Oh, you went to school with me. Oh, this is my fraternity or sorority buddy, et cetera, et cetera. Those networks create more homogeneity, less heterogeneity, less diversity, and we start to get groupthink, so we have to be really careful about that. Lastly, we want to make sure if we are going to have a recruitment system in place, it should be a formal system. We can't rely on real casual approaches to recruitment, because good recruitment makes selection really easy. So if we're not doing a good job with recruitment, our selection downstream is going to be problematic. So make sure we've got a good formal system in place that's legal, it's validated, that we're using resources that we know are going to provide us good candidates, and we're not going to be discriminating. And when we set those in place, that's very helpful. Along with barriers in the recruitment process, there could be barriers in our advancement and promotion process, in essence, for our internal candidates. Number one would be if we don't have a really good performance management system in place, so we're not giving good feedback, we're not doing good performance evaluation, and we don't have a good promotion process, a standardized process in place that we can refer back to. Other barriers include little or no access to informal networks of information and communication by people who are in protected classes. And what this means is the water cooler, or the good old boys network, or the good old girls network, where information about jobs is only communicated amongst a small elite group of people. So if job opportunities and advancement opportunities are only open to people who go to the golf course, those who don't golf would not have access to that. And this is a real problem, where we assume that the social network that we're surrounding ourselves with is broad and it is inclusive of everybody. So when we use informal networks of communication, even within the company, we're creating barriers for everybody to find out about information. So if there's advancement opportunities, if there's internal hiring opportunities, we need to make sure everybody knows, anybody who is eligible, and even people who we don't think are eligible. Everybody needs to know about employment opportunities and development opportunities and advancement opportunities, so that we are broadening the pool so everybody has a chance to apply. We want to also make sure we don't have different standards of expectations for different classes of employees. Upper level managers are allowed to get away with a whole host of different activities, but lower level employees don't get those same privileges. We want to make sure everybody is held to the same standard in the company. Otherwise, we run into problems with feeling like there's discrimination. Lack of equal access to assignments that are visible or that gives people interaction with powerful decision makers in the organization. So everybody needs a development plan, and we need to have a concrete development plan that every employee should have access to and be allowed to participate in if they want to grow and advance. So when we develop succession plans, we need to have a clear list of the things that someone needs in order to be eligible for succession, to go up and to be promoted, so that we have a plan in place for them to develop the skills needed so they can get promoted downstream. Lastly, making sure that that we include EEO, HR personnel in the recruitment process for higher level jobs. We want to make sure that those higher level jobs are casting a wide net amongst a whole diverse group of individuals and making sure we are considering everybody possible for the job. So if we don't have somebody who has EEO expertise sitting on that team, it's going to be really easy to become similar to me. That's similar to me bias. If I will only want to promote people who look like me and act like me and think like me and talk like me, the last thing we want is homogeneity in the workplace. Along with barriers to recruitment and advancement may also be the terms and conditions of employment in the organization. There can be barriers inherent in the policies and the systems that we have in place. For example, we may have a policy of unequal pay, or we may have unequal pay in our organization, even if it's not intended, and this can happen. So we want to make sure that we are constantly monitoring our pay differentials between men and women and majority and minority groups to make sure we're not seeing a divide amongst those groups, so that these, the protected groups are being paid less than the majority groups. We want to make sure we are not encouraging and allowing counterproductive behavior and harassment in the workplace. This could make us at risk for negligent retention, where if we know someone's a harasser, we know that they're engaged in poor behaviors and we're allowing those behaviors to continue, this creates a problem for the organization. We want to make sure we've got policies that are family friendly. That doesn't mean that only people with families get good benefits, right? And people who are single don't get them, because family-friendly benefits also are inclusive of single people who choose to define family and the way they want to behave in terms of interacting with others based on their own criteria. So we need, if we're going to have flexible policies for a family to, for a mom or a dad to go see their kid in a softball game, why couldn't we have the same thing for the single person who wants to go see their niece or nephew in a soccer game, or go and participate in a soccer game on their own? So the more that we allow for the flexibility of people's real lives to be accounted for both people who have nuclear families, mom and dad, and they have children, or moms and dads, of course, and also for people who are single, to have more family-friendly policies that also benefit them too. This is a good thing, and without that, then people will start to feel like they're being discriminated against because they have kids or because they aren't married. So all of those can be considered discriminatory behaviors. We want to make sure we have flexible working hours and working conditions. And what I mean by this is, it doesn't mean that we can say, hey, we need somebody here at 8 o'clock, and if you're not here at 8 o'clock, it's okay for you to come in at 10 or 12. And if your job requires you to be there at 8, you should be there at 8. But we want to make sure that they're not unreasonable for people, right? So to say that you've got to work from 6 o'clock in the morning to 6 o'clock at night with no breaks, that's not reasonable. That's not good working conditions. We cannot have people working on an assembly line and never being able to take a bathroom break. And OSHA has had to create rules and guidelines about making sure people get bathroom breaks, because in some manufacturing environments, people weren't being allowed to go for breaks because it would interfere with the manufacturing process. So it is really important that we make sure our working hours are reasonable, they're not inflexible, that we allow for a little bit of flexibility. If someone says, hey, I've got a childcare issue this morning, I'm going to be in at 8:30, that we don't punish them and say, no, you get docked hours or docked pay, or you're going to be punished, or it's going to be a demerit against your, against your working record with the company. Human beings have human issues that they have to address. And so as long as we account for it and we have a system in place where people can step in when there's gaps, when people have real life issues that they have to deal with, this is a benefit for us. Lastly, we want to make sure we are providing reasonable accommodations for all qualified people with disabilities. And so make sure that we're clear on what is considered a disability, make sure that we're clear on what kinds of things are reasonable accommodations or what are not considered reasonable. Most accommodations are pretty reasonable. Most of them really don't require much effort in order to accommodate, whether it's just getting somebody to lift a box for somebody with a back problem, or getting an amplifier on a telephone, or an elevated desk for somebody with a wheelchair. These are not challenging issues, and there are still employers out there that will fight to make sure that someone with a disability does not have the right to have access to these things. Lastly, we have barriers in termination and downsizing, with respect to equal employment things. For example, if we have unfair standards when we're making layoff decisions, we're saying, oh, it's performance-based, but we don't have a really good performance appraisal system. Or we might say that, well, I like these people, so I'm going to keep them, but I'm going to get rid of this person because I don't like them. And those are illegal criteria and inappropriate behaviors. And remember, if we have a bona fide seniority system, the bona fide seniority system has to be in play. You have to do layoffs based on the LIFO method, last in, first out. Even if you have more diverse hires in the later years and they have less seniority, you cannot hold them and hold their jobs and lay off someone that's more senior. Bona fide seniority systems are incredibly important, and a bona fide seniority system is typically a system where people have real clarity about who is more senior and who is less senior, who has the rank and who does not have rank. And so you will know if you're in a company that has a bona fide seniority system because it's very clear. Where do we typically see bona fide seniority systems? Firefighters, police officers, and usually first responders of some sort. Military has an issue of rank and seniority. Unions have real clarity around rank and seniority. So be aware in your company whether or not seniority is a big issue. Next, having inadequate plans for layoffs. For example, you're doing layoffs, but you don't have a plan for how you're going to do it. Is it based on good performing or low performing divisions or departments? Is it about low performing employees, and do you have records of who's a low performing employee and who's a high performing employee? Do we have policies in place to manage that? So we have to make sure then we've got a good performance appraisal system that supports that. Next, lack of communication between employers and employees. Actually, I just skipped one, but let me answer that one first. Lack of communication between employers and employees. We need to have transparency. We shouldn't be hiding things from our employees. If we're having financial difficulties, we should be communicating them. We should be letting them know we were having issues and allowing those employees opportunities to come up with ideas to save their jobs. They need to know the consequences in advance. Next, a lack of adequate incentives to encourage voluntary separations. So we want to make sure that if we're going to ask for people to voluntarily leave, to take early retirement, what have you, that you've got a good incentive for them in play. Otherwise, they're not going to take it, and you're going to be stuck. And then you're going to have to make alternative arrangements for your layoff. So make sure you've got good incentives in place that are fair and legal to be able to do that. The last item on this slide and of this slideshow is failure to provide counseling, job placement, and training to laid off employees. When you are laying people off, you want to make sure you provide opportunities for them to repackage their skills and find jobs elsewhere. So it's a better practice when you help people to reframe their job, help them with their resume, and help them to find jobs elsewhere. When we don't do this, then there is a lot of disgruntlement, and people then would argue, maybe I'm being treated fairly, maybe I got laid off because I'm a woman, or I'm a minority, or I'm a man, whatever it is. So it's important that we treat our people well so that the possibility for them to think that they're being treated illegally. Even if it's not true, it doesn't stop people from thinking that if they're not being treated fairly. So we want to make sure people are treated fairly.